It's noon in Arizona. Welcome live from the Carpenter Law Firm studios. This is Advanced Insurance Issues for 2024. My name is Scott Carpenter, and this is one in our continuing series of legal issues for Arizona's community associations. Today, the topic is insurance issues. This is a hot topic in Arizona, really across the country, for a number of reasons that we'll get into today. The first is that costs are up. Costs are way up. And for those of you participating today or watching this seminar later, you know that costs are up for insurance of community associations in all areas of insurance. And there's one primary reason that we can point to, and that is the Champlain Towers South 12-story beachfront condominium collapse in the Miami suburb of Surfside, Florida. A bit of detail about that. It collapsed on June 24th, 2021 at 1:22 a.m. Eastern Daylight Time. Now, of course, this was a horrible tragedy in the middle of the night, if you can even imagine. You're sleeping, it's 1:22 a.m. and the building collapses. As best we can tell, and I of course am not involved in this in any way whatsoever, I have lawyer colleagues in Florida that are involved, but attorney-client privilege, we don't talk about it. The Community Associations Institute out of Virginia puts on an annual law seminar. We get together once a year and collaborate. There are roughly 700 to 800 of us lawyers that represent community associations, across the country. They get together each year. And so we know what's going on roughly, but as best we can tell, there was a long-term degradation of the reinforced concrete structural support in the basement parking garage, basically water penetration of the reinforcing steel. And this contributed to the collapse. Now, that's the best current information that we have. And of course, there were insurance claims due to this collapse. 98 deaths, 11 injured. And because it's America, massive lawsuits, massive litigation, wrongful death claims, personal injury claims, and insurance companies have to respond to these various claims. Lots of law firms seeking contingency fees, although a number of the law firms that were involved, at least the early information was that they were not going to take a contingency fee. And the judge overseeing the case was thankful for that, of course. So insurance rates are up across all insurance types. Now, is it really true that the Champlain Towers case resulted in such monumental losses that insurance rates have to go up in Arizona? I doubt it. I mean, you really think about it, the losses at Champlain Towers are isolated. There's a limit to that. Why would the claims there mean that Arizona rates have to go up? Is there some, as we say, profit taking going on and raising the rates across the country and saying, well, we're raising the rates because of, and then just point to the Surfside collapse? I don't know. I have no information to believe that's true, but there may be some vendors across the country who are saying, well, there's inflation, so we're going to raise our fees. Do they really need to do that? Or are they raising their fees and saying, well, blame inflation? I don't know. But regardless, insurance rates are up across all insurance types. And these insurance types are going to really be the outline for my presentation today. property and casualty, D&O. Sometimes we say this quite quickly, and it kind of slurs into one word, D&O, 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 directors and officers insurance. Now, it actually covers more than directors and officers, but it's a second type of insurance that community associations obtain. And the third is general liability. Now, costs are up across all three types, and we have to be prepared for that. So for 2025, we have to assume increases, and I've been saying this for probably 20 years. We have to raise assessments. The time when we could say, well, we're going to crunch the expenses down into a finite amount of income, and we're going to keep the assessments the same as last year, and we're going to work the budget, sharpen the pencils, the old lick the pencil, and keep working the numbers and keep working the numbers until we get the expenses down and crunch them, fold them and knead them, and make sure that the expenses fit within the assessments, a finite amount of assessments. So if we say, well, there's 100 lots and the tolerance is that people will only pay $100 a year in assessments. I'm making that up. That doesn't actually make any sense, but there's 100 lots and they'll only pay $100 a year in assessments. Then we have $10,000 worth of annual income. Now multiply that out for the community you manage or that you're on the board of directors of. And I've made my point. We have $10,000 of annual income. And then the task is make sure the expenses never exceed $10,000 because that's what the math requires. Last year, the assessments were $100 a year across 100 lots. That's $10,000 of income. Now multiply that out for the 2,000 lots in your community and the fact that it's $89 a month. Do whatever math is required, but the mentality is the expenses must fit within that amount of income. So what does it require? Well, it requires that the insurance can't be more expensive. Well, it is more expensive. The landscape maintenance is more expensive. The legal fees bounce around from year to year. And the water costs go up and down, more up than down. And all the other various expenses in an average community association budget go up. They don't go down. If you look at an association budget and the expenses in 2025 and compare it to 1995, it's more expensive today. The idea that the assessments could be static, meaning they don't change from year to year, is naive. And I hate to say it that way because there are a lot of people who believe deeply and strongly that the assessments can stay the same year to year to year. But great professional community managers disabuse boards of that and try very hard each year to disabuse of that. But insurance is one of those examples where we cannot indulge in the fantasy that the cost of insurance will remain static, will remain the same year to year. So the first point in my presentation today is the costs are up and there's no indication that they're going to go down. That's one of the great fictions of inflation, is that once costs go up, they tend to not go down. And this is not a political comment, but over the last several years, the rate of inflation may go down, but the cumulative effect of inflation, up 20% over some period of time, is that the cost of eggs, bread, gas, whatever, is still up 20%. And someone might say, well, inflation was only up 2.2% over the last quarter. It's still up 20% over the last however many years. And that's true for community associations as well. So if someone were to say, well, our assessments haven't gone up, over the last 3 years, what are we doing? How are we meeting our expenses? So that's my first broad observation. So we talked about these 3 areas. I'm going to talk about each one specifically and talk about some of our advanced challenges within each area: property and casualty, D&O. And when we say it quickly, reminds me of something from law school. I went to Baylor Law School in Waco, Texas, and I was in Waco, those of you around long enough, for the fault compound problem back in the early 90s. But when I got to Baylor, people were talking about a required class in the 3rd year, and I didn't understand what they were saying. It just seemed like a weird Southern drawl problem. They were talking about a required class called oil and gas, oil and gas. Well, I finally figured out they were talking about oil and gas, but it was such a drawl, and you don't think of Waco, 100 miles south of Dallas, being a particularly Southern drawl kind of place, but oil and gas, oil and gas. Well, by the time I got to my 3rd year and I was taking oil and gas as a required class in law school, because it's Texas after all, you got to learn about oil and gas law. I was saying oil and gas, oil and gas. So we slur D&O, but it's directors and officers D&O without the slur. General liability. Let's talk about property and casualty first. This is the insurance that insures against damage to physical structures. If we were to draw an analogy, in a single family home, this is the tornado tore off the roof of your home insurance. This is property and casualty, and it's required in a condo. There's a statute that says you have to have property and casualty insurance in a condominium, and it generally insures the exterior because it's required to insure the common elements. We don't say common area in a condominium, it's the common elements, which is everything except the units. So this is the property and casualty insurance. Quick footnote, and I'll repeat this a couple of times. Although there's a statute in the Condominium Act that requires property and casualty insurance in a condominium, there are no statutes for planned communities that require any insurance in a planned community. Sort of an important footnote for professional community managers. In a condo, we have to follow the statutes that dictate how we handle insurance, but there are no statutes in a planned community that dictate anything regarding insurance in a planned community. So what are the advanced issue components that we seem to deal with in a property and casualty context? Well, the first one is that the association is obligated to maintain this property insurance on the common elements, and if the documents, the declaration, CC&Rs, require it, the association might be obligated to maintain property insurance on the units. And what does this insurance have to do? Well, by statute, it has to insure against all risks of direct physical loss commonly insured against. Now, already we've run into a little bit of trouble here. Commonly insured against. This is already a bit questionable. Commonly insured against what? By other condos in Arizona? Commonly insured against by people who own buildings? This phraseology has always been a bit troubling, but it probably means commonly insured against by other Arizona condominiums, but it's never been litigated. There's no case law, there's no decisions or opinions from courts that have interpreted this last phraseology. The total amount of insurance after application of deductibles cannot be less than 80% of the actual cash value of the insured property at the time the insurance is purchased and at each renewal date, exclusive of the land, excavations, foundations, and other items normally excluded from property policies. So if I insure my house, a property and casualty policy, again, referencing bullet point number 2, property and casualty doesn't include the land or the foundation, because if a house burns down and I have to rebuild it, the foundation is still there in theory. So that's why these things are generally excluded. So the good news is that a competent insurance broker who sells condominium insurance understands how to quote and sell property and casualty insurance that meets this requirement. This language here is verbatim from the statute that I just mentioned. The Condominium Act statute that says the association is obligated to maintain property insurance on the common elements, and if the documents require it, on the units, but it has to be at least 80% of the actual cash value. So we're doing this already, because if you're using a reputable condominium insurance broker and they're quoting condominium insurance, most of these insurance companies are complying with the Arizona Condominium Act. So this is the first requirement of the Arizona Condominium Act, is to quote the insurance within the very first requirement of the statute that speaks to condominium insurance, 80% of the actual cash value. So no problem. Usually this is not where we run into trouble. Now, the second piece here, which happened a couple of years ago, but how does this happen at the legislature? The legislature is a place where homeowners go and complain about their own experience. So an owner supposedly had a loss in their unit and they wanted to make a claim on the association's property and casualty policy. Now, from the owner's perspective, you can say, well, the policy is owned by the association. The owner is not the policy holder. The owner is not the insured. I want to use a technical term. The association is the insured. So why would the owner have a right to make a claim directly on the association-owned policy where the association is the insured? Well, the owner was upset because the owner felt that the board was not treating the owner's position fairly, and the owner wanted to go to the association property and casualty carrier directly, but the board stood its ground and created a barrier between the owner and the association-owned property and casualty carrier, and did not permit the owner to make a direct claim. And so the legislature stepped in and said, well, you can't do that anymore, board, and here's why. The owner's assessments are paying the premiums on that association-owned policy. And because the legislature didn't explain it this way, but it's the logic. Because the owner's assessments are paying the premiums in part on the association-owned policy, the owner has to have access to make a claim directly to the association-owned policy. So the owner can report a loss directly to the association carriers that the association is paying the premiums directly to. So although the owner can report a loss directly to the carrier, now I'm at the third bullet point, the owner has to go to the association first and give the association 10 business days to provide the unit owner with a written decision on whether the association will be reporting the claim to the master policy. If the association decides not to report it, the association has to give a reason to the owner in writing, and then the owner can go directly to the carrier. So it's not that easy for the owner. The owner has to go to the board first, and then the board has to decide whether to make the report directly to the carrier, and then the owner can go to the carrier directly. A bit of a compromise, if you will, by the legislature. There's really no evidence, from my perspective, that this is happening in droves. It's not like there are hundreds of claims being made by owners to condo, property and casualty carriers directly. And part of the problem that we have, part of the problem that exists is an owner goes to the legislature, obtains a somewhat obscure right like this, RIGHT, and that allows an owner who's had a claim to go directly to the carrier. Well, think about it this way. An owner has an event at their condo, and they get the runaround and they're frustrated. It's difficult for that owner to figure out that they have this right. Are they a lawyer? Are they going to do the research? How quickly are they going to find this statute in the Arizona Condominium Act? It's not that easy. And when they go to say, well, I need to hire a lawyer, what lawyer are they going to hire? How many lawyers in Arizona know about the statute? There's only a handful of us that are in these statutes all day, every day. I mean, think how many of us are there really statewide? 50, maybe? And those of us that are really in it all day, every day, we tend to limit our law practices to representing associations. We don't spend time representing owners against associations, nearly all of us. And so owners have a tough time finding these rights that were obtained by one aggrieved citizen. So although we can say in an academic environment like this, an owner, second bullet point, an owner can report a loss directly to the association carrier. After this back and forth with the board, third bullet point, it becomes somewhat academic in the sense that we can talk about it and we can be aware of it, but the association board of directors and the professional community manager are not obligated to inform the owner of this right. It's the owner, the aggrieved owner's obligation to figure out their own rights and abilities under the statute. We, you, the board, professional community manager, are not obligated to say, well, Ms. Owner, Mr. Owner, you've got beef with the association and its process of tendering claims under the property and casualty policy. Let me whisper in your ear. I attended a seminar by Scott Carpenter. You may have a right to go directly to the carrier. We don't do that. Not suggesting you would. But other than that, the chances are actually pretty low that random homeowner is going to figure this out. I'm not saying that's a good thing. I'm not saying it's a bad thing. But statistically speaking, in all the years that I've been doing this, representing condominium associations in Arizona, the legislature has a kind of a high sense of itself that they can fix this problem, and then the awareness of it will just at lightning speed be sent out to all the owners who will need it and want it, but it doesn't happen that way. It doesn't seep into the collective consciousness like a Vulcan mind meld out into all condo owners immediately. It doesn't work that way, as you know. All right, let's talk about D and O, directors and officers. I'm not going to slur it anymore. I think I beat that to death and told you a story that was a little TMI about law school back in 1990, whatever. It was like the Wonder Years. Back in 1980, whatever. I'm not going to do it again. Here we go. Directors and officers. In theory, the directors and officers policy, by the very name, it covers the directors and officers from and against claims. So an owner sues Bob the president, Sally the director, Tom the treasurer, and Blake the secretary, and says you breach your duty because you're not doing what you should be doing, or you are doing something wrong. And I'm suing you in county superior court. Could be Navajo County, Maricopa County, Pima County, Pinal County, Santa Cruz County, whatever. 15 counties in Arizona. It covers the directors and officers from and against claims brought by an owner. You're doing it wrong. You're doing the wrong thing. But directors and officers insurance covers the obvious, but it also covers non-monetary, can also cover non-monetary claims against the association, such as Arizona Department of Real Estate claims. We used to call these ALJ claims, administrative law judge claims, where somebody pays $500 and goes to the alternate dispute process at the Department of Real Estate. It's a way of litigating against the association without having to go to Superior Court. But if it's covered by a directors and officers policy, the owner is still litigating against the association and a lawyer paid for by the insurance company, which is kind of what I'm getting at here. Non-monetary claims against the association, ADRE process claims. Footnote here, I've said before, for you, those of you who have followed me in my legal thinking, the Arizona Department of Real Estate process is unconstitutional under the Arizona Constitution. It's an adjudicatory process that violates the separation of powers. That's all I'm going to say. I had it declared unconstitutional in a case about 10 years ago that went up to the Court of Appeals and the Arizona Supreme Court. Then the next year, the legislature brought it back. It's still unconstitutional, kind of waiting for the right case to have it declared unconstitutional again. But why is it still around if it's unconstitutional and all the lawyers know it? Perhaps it's because the insurance defense lawyers like to go there and like to make money defending people there. I don't know, that's a bit cynical. Maybe I don't really mean that. It also covers non-monetary claims, such as claims from an owner against the association seeking an injunction. An owner sues the association and wants an injunction against the association, claiming the association is guilty of failure to enforce. Judge, we want an injunction compelling the association to enforce the CC&Rs against the purple gazebo in the front yard of Lot 7. Judge, please enter an order compelling the association to enforce the covenants, architectural restrictions against the owner of Lot 7. An injunction claim in Superior Court alleging that the board is meeting in a closed session, violation of the open meeting law. Books and records violation claim brought by an owner. Judge, we want an injunction forcing the association to provide books and records. Or a claim in Superior Court accusing the association of fair housing claims. That may be a non-monetary claim. So these are issues under the directors and officers policy. Now, one thing that comes up is the difference between a policy paying defense costs and whether a policy pays indemnity if the association loses. This is extremely important, and this is an advanced issue because a lot of associations and professional community managers assume that if there's a claim a demand letter, a lawsuit, a claim at ADRE, Arizona Department of Real Estate, that when you tender it to the carrier, what does tender mean? Send it over, scan it, and email it to the broker. That's a tender. Ask them to cover it under the policy. That's a tender. When you tender it and they respond back and say, we've assigned a law firm to defend you, most people assume, by the way, I don't. I'll tell you why in a second. They assume that when the carrier assigns a lawyer to defend the association or the professional community manager, directors and professional community managers assume that with the assignment of a lawyer to defend, that's it. That's good news. We're covered. But that's not actually what's happening. Under insurance law, there are two different duties, potentially. We call this the duty to defend and the duty to indemnify. They're two different things. Under a policy, there may be a duty to defend, which is exactly what it sounds like, a duty to assign a lawyer and to defend the insured. Now, who's the insured? It may be the board, maybe the professional community manager, who could be an insured under the D&O policy. It might be the management company, the board members, the manager, the management company, all might be insured under the directors and officers policy. So the duty to defend means hire a lawyer, law firm to defend the insureds under the directors and officers policy. That's the duty to defend. The duty to indemnify is a similarly straightforward thought. It means if you go to the end and the jury says, all right, association, you lose, it's $1 million, cut a check to the plaintiffs, the people who brought the case, you lose. The duty to indemnify says the insurance carrier has to write a check to the association for the $1 million so that the association has the $1 million to pay to the plaintiffs. That's what the duty to indemnify means. So under insurance law, and we're a little off community association law here for a second, but we have to be in this context. In insurance law, there's the duty to defend and the duty to indemnify. So what happens often in community association law under the D&O policy is that the carrier assigns a law firm to defend. And we think, well, it's great. We're done with the carrier. They've hired a law firm to defend, but we forget that the carrier may be committing to the duty to defend, but they have not yet committed to the duty to indemnify. They haven't done that. They assigned you a lawyer, but the duty to indemnify is still hanging out there. They have not committed to that yet. And this matters a tremendous amount because I have been in many court cases where a carrier gets to a mediation or settlement posture and at the last minute says, hey, wait a minute, we're not sure about indemnity. We paid these lawyers up to this point, and we're up to our eyeballs in legal fees. We've already paid this insurance defense law firm $85,000 to defend you, HOA, double Gavista. And it's going to take another $50,000 to settle the case. The plaintiff wants 50 grand. But we haven't committed to indemnify you. That's the money that they want at the end of the case. We committed to defend you under the policy, but we're not sure at this moment, at the end, at the mediation. It's extremely annoying. It's maddening. It's angering, actually. You're at the mediation, trying to wrap the case up, and the carrier says, time out. If it's going to take 50 grand to make the case go away, HOA insured, partner under the policy, you paid the premiums, we're not here for you. We defended you. We're not sure the policy obligates us to indemnify you. What they did, but we lose sight of it, is at the very beginning, they sent a letter called a reservation of rights. They said, we are assigning a lawyer to defend you, but we are reserving our right to take the position down the road that we are not obligated to indemnify you. So what ends up happening in many cases, and this is no judgment on standard management company practice or anyone watching this seminar, is that when the attorney is assigned to defend, we fall into a kind of a celebratory mood. There's a lawsuit that's been filed. We're a little nervous about it. What's going to happen? Oh, good. The insurance company has assigned a lawyer to defend, because the legal fees to defend it are a potential mountain of problems. We have a reserve fund. Legal fees are expensive. We all concede that. Once the law firm is assigned to defend, all you have to do is pay the deductible. Now we're good. The reservation of rights letter looks like a form letter. It doesn't elicit a big reaction. It's just a kind of a form letter from the insurance company. But when you're in the mediation at the end, and all of a sudden the insurance company says, well, it's going to take 50 grand for the case to go away. And oh, by the way, we're not paying that. Remember the reservation of rights letter, and the board members are in the mediation with the retired judge looking at each other and saying, what is he talking about? What are they talking about? I don't remember a reservation of rights letter. And you're the professional community manager scrambling around in the mediation saying, well, that was 15 months ago when the lawsuit was filed. I don't think I could put my fingers on it real quickly. And the defense law firm doesn't even have a copy of it, because there's a wall between the insurance defense firm and the coverage issues. So it's complicated. I'll come back to that topic. We'll wrap it up as neatly as I possibly can. General liability, the third type of insurance. Property and casualty, directors and officers, now general liability, and then we'll wrap up a couple of thoughts. This covers the general liability of the community. Let's use an example. A tree root is lifting up the sidewalk to the clubhouse, and Beatrice, your 90-year-old resident, trips and falls on the lifted portion of the sidewalk, breaks her hip, develops sepsis, and dies. The sidewalk and clubhouse are on common area in a planned community, common elements in a condominium, switching up the hypothetical to help us envision it a little more clearly. Now, it's somewhat difficult for a wrongful death claim for the family of a 90-year-old to be a big number, because what's the life expectancy of a 90-year-old? Let's make Beatrice 50 years old. The numbers are bigger for a 50-year-old than a 90-year-old. But somebody trips, they fall, break their hip, develop sepsis, and die. It's a wrongful death claim. It's a trip and fall. In certain parts of the country, it's an icy sidewalk. Here, it's lifted. The lip is so much that they trip and they die. from some condition. Well, here's an advanced question. What's our policy limit and what's the coverage for 2025? Is this a condition that we're concerned about? How sure are you that this could never happen? I've had cases before where there was an APS electrical box on the property and the association didn't have it fenced off. Some kid, walks by it, ends up in there and gets electrocuted. That's a wrongful death claim. And the association says there's an APS box. We had nothing to do with it. The claim was, well, the association knew it was there and should have had it fenced off. You can create all kinds of hypotheticals. I don't need to create hypotheticals. These things have happened to my clients, whether it's fencing off a APS electrical box. I had a case a number of years ago where the association was doing construction at a pool and the contractor put up a temporary construction chain link fence. And the 3-year-old boy crawled through the hole in the fence and drowned in the pool. Well, the association got sued, of course. And, that's a multi-million-dollar problem. Today's seminar is not about grotesque hypotheticals. So let's talk quickly about the insurance rubric that every association has to think about. In every association, there are risks you are going to keep, and there are risks you're going to shift. This is true in the household as well. I raised 3 daughters. They were all teenagers at the same time. They're 2 years apart. And when they were driving, there were risks I was keeping. There were risks I was shifting. Anybody who has teenage drivers does the same thing. Well, you're always keeping from 0 to your maximum deductible. That's obvious. You keep your deductible risk, and you're keeping the risk above your policy limits. If you have $1 million policy, you're at risk for the first dollar above $1 million. That's why people have umbrella policies. That's why people and associations purchase excess policies, because you're at risk up to the deductible and above the policy limits. We don't know what the risk is here for the 50-year-old who trips on the sidewalk, greater than the 90-year-old. How sure are you that you don't have tripping hazards in your community? It's not just about tripping hazards. It's about the fence around the pool. It's about everything else too. We've got the issues. And then there are uninsured components or areas of conduct where those are risks we're keeping. Do we have fountains that have a drowning risk where the water is too deep at the entrance? Are there other issues? There's all kinds of risks that you're keeping. Lake communities are particularly challenged in this regard. So there are risks that we're keeping, and then there are risks that we're shifting. From the deductible to the policy limit, we're shifting, and we're shifting covered acts and covered events. When I say covered acts and covered events, what does the policy cover? Those are risks we're shifting. Now, here's what is happening in the real world. Where do we start in terms of coverage? We start with the statute, but only the Condominium Act. There's no mandatory coverages in the planned community statutes. It's now a footnote. I mentioned it earlier. We start with the coverages required by the statute, coverages required by the governing documents. Often the CC&Rs have mandatory coverages, and nearly all management contracts have mandatory coverages and limits. A good insurance broker always quotes insurance based on the statute, the governing documents, and the management contract. And that gives a good overall starting point. But it has to be a starting point because then an understanding of the physical environment of the community. Is there a lake? What's the pool situation? How risky is the physical infrastructure? All of those things come into play. What's the loss history? Things like that really have to come into it. And then once we have our rubric done, which is really something the board can do with professional management involved, what are we keeping? What are we shifting? And are we at least obtaining the minimum required by the statute, the CC&Rs, and the management contract? And by the way, I don't know if the management contract minimums are acceptable, good or bad for the association. The management contract minimums are really there for the management company's purposes, but they're required if the management contract has been executed and agreed to. So those are not necessarily good for the association, but they are required, contractually required. So we have to quote those and obtain those either way. All right, let's talk about our special considerations and we'll take questions. Some associations want a choice of counsel provision in their policies. Now, the general liability and directors and officers are the policies that end up in litigation. General liability, who's defending the association in that lawsuit over the tripping on the sidewalk. And in the directors and officers policy, which is really where most of the litigation ends up, do you have what is routinely referred to as a choice of counsel provision? Meaning that as the insured, you can pick your own lawyer to defend you, the association, in the litigation that results as a covered claim under the policy. Most of the insurance companies don't want to do this because they have pre-negotiated an arrangement with certain law firms in the state, certain reporting requirements and other complicated budgeting rules and reporting requirements. It's actually somewhat complicated. And so it's hard to obtain, but it is a special consideration. Sometimes you can negotiate for it, a choice of counsel provision. That's what this is. Can you keep your preferred lawyer? Now let's talk about this reservation of rights letter. What would happen in an ideal situation is when an association receives a reservation of rights letter, if money were no object and we have plenty of time, then when an association gets a reservation of rights letter, the association would hire what's called coverage counsel, a specialized type of attorney who spends all day, every day on insurance coverage issues. Like I spend all day, every day on community association legal issues. There are lawyers who spend all day, every day on insurance coverage issues, and they are available for hire. And when an association gets a reservation of rights letter, after the carrier commits to defense, but says we're reserving our right to deny indemnity down the road, when that letter is received, if we were a Fortune 500 company and we had plenty of money and plenty of time, the whiteboard move is hire a coverage attorney to evaluate the legal correctness of the reservation of rights letter. Is it correct or not? It could be wrong. The carrier could be misreading their own policy. They could be wrong about the duty to indemnify. They could be wrong about whether they have the right down the road to deny a duty to indemnify. They could be wrong about reserving their right to deny indemnity down the road. So a separate coverage opinion letter, because we know from experience what's going to happen, what could happen, I should say. We don't know for sure what's going to happen, what could happen. They assign a lawyer under the duty to defend. They simultaneously send the reservation of rights letter. We litigate for months. We end up in a mediation where a retired judge puts the parties in separate conference rooms. The retired judge goes back and forth between the separate conference rooms, trying to facilitate a settlement. We get to the end. The adjuster for the insurance company is available by conference call. The adjuster's in a cubicle in Hartford, Connecticut. And all of a sudden, we get to the end. It's going to take a $50,000 payment to the plaintiff for the case to go away. And the adjuster says, we're not indemnifying. We said that in our reservation of rights letter. We're back to the scramble. What letter? What are we talking about? Blah, blah, blah. The insurance defense lawyer shrugs his or her shoulders and says, we have nothing to do with coverage. We're only defense. We don't represent the insurance company. We didn't write the letter. We represent the association only. We're paid by the insurance company. We represent the association. We have nothing to do with that. Take it up with the adjuster. Well, now the board members who are at the mediation have to talk to the adjuster in Hartford who wrote the reservation of rights letter and are at a supreme disadvantage because there's no separate coverage opinion from an independent coverage lawyer. It was never separately evaluated. And like I said, 9 times out of 10, the professional community manager is scrambling to even find it. No insult intended. So this is what happens in this special consideration at the end. That separate coverage opinion letter is not going to be cheap. It's not going to be fast necessarily. But if we don't do the homework at the beginning when the reservation of rights letter is sent, then we're going to be 15 months into litigation, we'll be at the mediation, and the carrier will say, well, we defended you, but we're not sure we're going to indemnify you. This settlement, this 50 grand, and I'm making that number up, it could be higher, it could be lower, that payment to the plaintiff to make the case go away, we're not doing that. We're not part of that deal. But maybe we'll split it with you because we don't want to pay any more legal fees to defend you. And now the board has to decide, how badly do we want to be done with this? Can't tell you how many times I've experienced that in my career where I'm the insurance defense lawyer and I'm watching all of this go on and I'm just beside myself because I have to say I have nothing to do with the reservation of rights letter. I represent the association and I'm watching the drama unfold that the board did not get a competing reservation of rights letter or even evaluate whether the reservation of rights letter was meritorious or correct. So let's talk about excess policies. One of the things about the trip and fall is that the general liability carrier really has an incentive to settle that case and not go to trial. So we don't really know what that case is worth. They're going to look at it and say, well, let's try to settle it as quickly as possible. So it's hard to know how much insurance we really need. But a lot of associations look at it and say, well, we've been carrying $1 million of general liability insurance for 30 years. But why? Is that based on jury verdicts? Is that based on some kind of scientific understanding or data-driven understanding of what a case would actually be worth in terms of a jury verdict? Or does it just seem like a big number? But when you think about what a general liability case would be worth, why do we carry $1 million? And my suspicion is we carry $1 million because it seems like a big number, but you can create a lot of scenarios where a jury might award a good bit more than $1 million. And $1 million limit would not nearly be enough. I started practicing in this area in 1994, and we were doing $1 million limit requirements when I started 30 years ago. Why are we still carrying that low a limit? I haven't seen any data that suggests that juries are coming back with jury verdicts that low in a range of hypothetical or a range of real general liability cases. Maybe in the D&O realm, they don't get that high for books and records or open meeting silliness. In fact, rarely are those monetary claims anyway. But in the GL, I mean, 50-year-old on a sidewalk dies. Why do we think a jury is going to award $1 million or less in that scenario? We've got to be really smart about our excess policy considerations and whether the limit of 1 million is even smart anymore. All right, any questions? We use the chat when we do a webinar format for the Q&A. If not, that's okay. It means I covered it. I covered what I intended. I did not change the date on my questions slide. I see that today is November 19th, 2024. Everything I've presented today was intended to be accurate as of November 19th, 2024, live from the Carpenter Law Firm Studios, which is my office with a green screen. So thank you for joining me on this continuing series of legal issues confronting Arizona community associations, and I hope you all have a great rest of your day or whatever portion of the day you're watching this. Thank you all.